give to a chief officer during the whole tendency of the case, but despite his
She said she'll let him put it on the record. The record. She has no intention of running it. Wow. That's it? Oh boy. Oh my goodness. Oh my God. Um, not know that. They choose the jurors by the judge? Wow. I think that's what she said. He gads. I have to rewatch this on captions. So this was the going over. I didn't realize they were doing this today because NBC 10 dropped the ball and just closed up like it was over. So yeah, they just went over the instructions, and she's not made her decision. She will let them know. Um, hmm. My conclusion on this case is that I'm very, very, very disappointed in Jackson shortcutting the defense um, by not calling the people who were bit by Chloe the dog to really hammer home to the jury that, in fact, they were lying. And it's important because this is a case where, we at home who've been watching the trial every day, we know, right? 80% of the people are saying that they're corrupt, and that's without doing polls across the internet. So it's actually a little bit higher if you just do more limited polls that really don't give the accurate number, because people watching, those streams are more tending to be for what the person presenting, or streaming is. So they're kind of a little bit biased polls, but that's probably why they're a little bit higher. 80% across the internet who have the ability to research and know or listen and observe and know the things before the jury has seen it, and things that the jury will not see and did not see, we know. So we have more knowledge, so we can feel like, oh, we know they're guilty, right? But the jury doesn't know all that we know. It's been very limited to what the jury can hear. um, they don't know that uh, they don't know about the dogs. They don't know about the extent about them tearing up their basement and and then filling in their pool, and which kind of suggests that instead of taking the stuff that could have John's DNA on it to a landfill where people could access it, people can go dig up a landfill if they found out where they had dumped it. Yeah, people would probably do that. um I don't know. I mean, it could just be that you just wanted to fill in the pool because it was, been better for the sale of the property. It could be nothing. But just saying, they don't know that there was a cop who said that Higgins, who testified that he never went near her car, he just went through the Sally Port, was actually seen by a cop at that Sally Port for a long period of time. And that's when the 42 minutes of footage is missing, and he was with the supervisor. They don't know these things. They don't know a lot of things because there's a lot of things that didn't get to the jury. So the jury, in order for them to find her not guilty, would have to, I mean, I know that reasonable doubt, right? Reasonable doubt's all that's needed. And the experts alone, which is very problematic in our country, when you have both, all the experts for both the state and the defense are experts who can testify either for the defense or prosecution. And so when you have these same experts contradicting each other in very, clear ways, that's very problematic, because you have people being put away in prison on expert witnesses like that. And so how can they be so contrary to each other and yet both be accepted as valid science? It's a problem in our country's judicial system. I'm glad for her that she had expert witnesses that was hired not even by them or the state. So that was pretty strong. We can all say, oh, there's reasonable doubt, there's reasonable doubt, there's reasonable doubt, there's reasonable doubt. But when you look at the amount of people who are lying, it is hard to accept for a lot of people. Again, they're not on TV, they're not on internet, they're not on YouTube, they're not like watching stuff like we do. So we have to step outside our own boxes and look at it from just some random person who doesn't have time to do stuff on the internet. They're busy, they work, they don't even probably spend time on the internet. And so they have to accept that this amount of people have lied, and that amount of experts came onto the stand and testified that she did that. They have to accept that all those people are lying to come to the conclusion. They could just look at her and all her witnesses that are contradicting all their witnesses is just bunk. Then you also have to accept that this is a very, it's a long period of time, and you don't know how well they took notes. Were they bored? Did they really catch the things that we're catching? Like, for example, Trooper Guarini, he basically contradicted Trooper Paul. He contradicted several of the witnesses. There's no way she could have been there at 12:45 because she auto connected at Wi-Fi 12:36. You know, but based on what I saw from Jackson's motion to dismiss and the many things that he could have included that he did not, I am very concerned for the closing arguments. And I don't have the feeling of confidence that it's a guarantee they're going to acquit her, because juries are unpredictable and they're fickle. I mean, I'm not to well, I shouldn't say they're fickle, but I mean they can be, but it's unpredictable. I don't think that it's ethical for any attorney to ever cut a defense short because they feel too confident they're going to win. And that, to me, if she does lose, hopefully she won't, that's definitely ineffective assistance of counsel argument, in my opinion. Because when you have a case like this, that this isn't one cop who's lied on somebody. This is several cops and several state troopers and expert witnesses. It's overwhelming. It's a lot. This is a very large conspiracy, and it's even for people that even have heard and accepted their testimony, they're still wrestling with it. And it's almost psychologically injurious to a person who maybe has never looked at the cops like this amount of people could be that crooked. It's frightening, and they have to grasp that this is this many people lying. And so I think that he really shorted her. What would have really helped, everything and anything that they had to just really hammer home that these people are liars. Their confidence, they feel like the jury sees what they're seeing, and they just are overconfident, in my opinion. So everything they can present, they should have been presenting every single thing. And that means that cop who was willing to testify that he saw Higgins at her car for a long period of time with the supervisor, that is a cop out of the same police department who are conspiring against her. Okay? Then you have multiple witnesses that could have testified that that dog attacked them. And that would go specifically against the Alberts, because they testified that there was no incidents of dog biting a human. They admitted that there was like a dog that attacked another dog, but there was multiple allegations against that dog, to include hospital records. So to have those people testify would be even more evidence that those people lied. Because all that expert witness stuff can be really overwhelming to jurors and confusing. But when you got people going up there, like that snowplow driver, he was a pretty good witness. But even Lally got him to say the words, "I don't recall." But I think he overall, I mean, he was very slick in that manner. And Lally's issue with these FBI expert witnesses is that he keeps putting in there that there's the shoe, there's the hat, there's the glass, there's the this, there's the that. And Jackson nor YANETTI really went and attacked that action that he was doing. So he's trying to present that your testimony about that could not cause the injury is really not valid because you have all these little particles on the scene. And Yannetti could have said, okay, well, does these items on the scene have any relevance to whether or not that car caused the injury? And really stick it to him that no, it doesn't. These things on the ground, they don't matter, because if the injury doesn't match the collision scientifically and biomechanics and all the things that they study to, the things that he explained, if it doesn't match, then all that other stuff is not relevant. Because see, here's the thing, even if a state doesn't know how somebody died, they can present circumstantial stuff, even if it's accumulative, and they can trick juries into believing that something happened just because of things that they can plant on the scene. Well, there was the glass, there was the plastic, there was the shoe, there was a hat, there was a this, there was a that. And so he failed to really present that fact. When he cross-examined them and then, went back, he did at one point say, none of that matters. It's not relevant. He did say that at one point. But in the end of that second expert witness from the FBI, a very damaging thing got said that hurt all of their testimony, and Yannetti nor Jackson caught it. And it was very damaging, and here's why. Lally, was asking different situations of that could cause them to be thrown, and the expert witness had said, yeah, if they get nudged or something, then they could fall over and hit their head. That's all Lally needed. And Jackson should have went back and said, so you said that if somebody gets nudged, then they could fall over backwards, but isn't it true that you've testified that at going 25 miles per hour, they wouldn't just fall over backwards, they would be hit so hard they would have very serious injuries? Because that now Lally has that, like oh wow, if you get nudged, you could fall over backwards and hit your head. He wasn't nudged. According to their theory, he was rammed at 25 miles an hour by a 7,000-pound vehicle. So it's not possible for him to be nudged and caused to be fall over backwards and hit his head. I guarantee you, mark my words right now as I speak. In his closing arguments, he's going to use that. He's going to tell this jury, even if you don't accept, even if you think that all of our scientific evidence is incorrect, you heard the witness say that even if it, was, and he'll change the words where it doesn't say nudged, it was struck by a car, it could cause him to fall over and cause that injury. I'm guaranteeing you that is what he'll do. Mark my words. And Yannetti and Jackson didn't recover from that. Like, they didn't, go and say, okay, isn't it true that he wasn't nudged? If, you said that, oh, it's possible that, being hit by a car could cause him to fall backwards and hit his head, and that could cause an injury. It's like, sure, if somebody's bumped by a car, it could cause them to fall backwards and hit their head. Just like a dog that jumps on somebody causes them to fall over, and they could struck his head on something sharp. It could have been anything. If he was in the basement, you saw the pictures of the equipment down there. There was one fitness equipment, and it had this really sharp piece. I mean, anything could have happened to cause him to fall over, but he definitely was wrestling with a dog. That's a given. But I'm telling you, Jackson, when he did his motion to dismiss, he omitted so many things. And for the judge to say that she believes the Commonwealth has proven his burden is just egregious, because you have animal control records that show that the Alberts are lying. Lally was allowed to suborn perjury, which is criminal. Okay, and none of Jackson nor Yannetti talked about the bar ethics and how if you know that this person is lying, you cannot suborn perjury. I mean, I don't know if they were just intimidated. I don't know what their issue was, but that is what they should have been saying, that the Bar Association of the Massachusetts and the American Bar Association, there's specific rules. You can go in on any state's bar association and you can download their rules, and it's very clear. You cannot, if you find out that one of your witnesses is lying and evidence proves that, once you become aware of that evidence, you have to correct the record. So for them to have said, in grand jury indictments or whatever, or in questioning, that their dog never attacked anybody, once they became aware of those animal control records, that there was allegations, there was hospital records of that dog attacking people, he cannot put them on the stand and then say that there was no allegations when he has possession of the bite records of the allegations. That is suborning perjury. And a lot of people think, well, it's just, they have their opinion, you have their, no, that's not how it is. Now, just because they're not practicing the law as it is written doesn't mean they're not committing criminal subordination of perjury. And this is so common in our country that it's almost becoming accepted as valid law that they can do this, and it's not. It's people need to stand up against that and say you cannot suborn perjury. So he knew, and then the judge and basically accusing this doctor who flew in to, that had the ER, Dr. Russell, accuse her of having reviewed reports of animal dog bites. So that told you right there the judge knew about reports that the dog bit people. And Lally knew. So you cannot then allow the Alberts to get on the stand. He didn't argue for that. He didn't present that in a motion to dismiss. Whether the judge agrees with it or not, he should have got it on the record. He didn't present that the 1245 was contradicted by Trooper Guarini. She's, logging in at 1236. It's not possible because of the distance between their house and to One Meadows Ave is 2.3 miles. It takes 6 minutes in light traffic. It would have took 10 minutes in the snowy conditions. And then you have the Fit app that says even Trooper Guarani said that yes, it shows he was walking at 12:32, and so it's not possible for him to be walking at 12:32 and her checking in Wi-Fi at 12:36. That's 4 minutes difference, and it took 2 minutes. So it's more likely that she left. And the time that it showed, that even Trooper Guarini says that Celebrite is pinpointed when the walking started, was 12:22 and 10 seconds. And then them saying that they never walked again, he never walked again after 12:25, it doesn't even add up. So then that he never walked again after 12:45, keep this in mind, he never walked again after 12:25. Then they're saying the collision happened at 12:45. So how do you have 20 minutes happening? How is he never walking again after 12:25? And yet the collision happened at 12:45, 20 minutes later. He didn't present any of these inconsistencies. Nothing. None. I mean, it was the worst I have ever seen in the history of America for a motion to dismiss. Jackson was just like checked out. He was just like, forget this case. Either that or he's just like going through the motions, do a little quick motion to dismiss because he feels like he's going to win. And, it's slam dunk. And they were very over. I just was like blown away by his awful motion to dismiss. That's definitely an ineffective assistance of counsel. Oh my gosh. But then when they're walking down the street and, talking to the media and saying that they are so sure that they're going to win, they're not even going to call the people who can testify that the Alberts were lying. They were hospital records, the whole 9 yards, that dog attacked people. Okay, that is such strong evidence. They're not even going to present the cop who's going to call another cop a liar, a state trooper a liar, or Higgins a liar. I mean, those are so powerful witnesses, and just to not present that when they need everything, and it is, and so for an attorney to feel like, well, I won, so I'm just not even gonna bother, that's ineffective assistance of counsel. I don't care that these guys celebrities. I don't care. I really don't. It boils down to a defense lawyer has the duty to present everything they can. And I know, oh, well, defense they're not even bound to present anything. Right. But when you have this amount of people testifying against her and this amount of experts that they're using, bunk science at that, she needed everything. And it's just it's just not, it's sad that he didn't argue, because he didn't argue to the judge on the motion to dismiss all those points. It can never be raised for appeal, you know. Anyways, but I hope and I pray that she is acquitted. I'm absolutely convinced that they're corrupt. I've just seen way too much. And then you have the fight that happened out there with this blogger. I guess it happened yesterday. I was a little concerned about something the police officer said. And it actually, in fairness, it wasn't suggested by him. It was suggested by the person who had the video. Those people, you remember the video that I shared, which, I'm sorry, I have problems with my esophagus. um, anyway, so the lady, Jill Daniels, she was ranting, and somebody recorded her. I believe she called back after she had been called or something like that, and I shared in a video where she was defending Colin Albert, saying that he was not in the house, or not at that time. She was saying Colin Albert was in the house, but prior to John and Higgins, and so she put John in the house, and she caught herself and she changed the subject. So that same person knocked the phone out of this blogger's hand or whatever, and then this other guy was over there lightly touching the lady in the dress just to be a nuisance. So he went next door to Chris Albert's restaurant to eat at this restaurant, and I don't even I don't really know if that violates any order to stay 100 feet away from any of them. I don't really know, but he was just in there trying to eat, and I guess some of those clan was inside there or something. So anyways, I guess they came out there after and knocked the phone out of his hand, and just, they were yelling back and forth, which to me is just disrespectful to the people inside the restaurant. They were both arguing back and forth, but they weren't assaulting people. They weren't knocking phones out of their hand, but those people were. And so there was some of the witnesses that was in during this trial out there, being belligerent. Um, I personally, and I know a lot of people will disagree with me, but I just don't, and I accept that I could be wrong in this, but I just don't feel that if there was a fight that it was Colin. I just don't. I feel that it was Higgins, just because of the things that he did. Colin didn't have the power that Higgins did. He didn't have the ability to go in the police station and be around that car and then lie and say that he wasn't there. He didn't have the power to be access to that car to plant things. He didn't have the text messages of romance between her and him. And he just, yeah, maybe there was some little tiff between them, but I just don't. Maybe he could have jumped in or something like that. I don't know. Only God knows, and the people that did it, right? And know about it, okay, that witnessed it. But I just personally believe that it was Higgins, if there was a fight at all. And I'm not completely convinced that there even was a fight, because when somebody falls, that dog could have just jumped him and caught him by surprise. And I'm gonna tell you, I've seen way too many videos of dogs jumping literally through glass and windows when they feel like they need to defend. And that dog was already on edge. You've got a dog who goes around and bites people, is an aggressive dog, probably has serious fear issues, and you've got a bunch of people there and a lot of noise probably, or just, you got a lot of people there. So that dog's already on edge, and it just could have, I don't know, got loose. I have a poodle, I did have, he's passed now, but he's so smart. He could open doors. He taught himself to turn the light on. Okay. He could open my car door. I'm like, just don't ever think that you can just stick a dog in a room. You got a bunch of people there that is an aggressive dog that attacks people. That's enough. It's not. It's negligence. What it is.